and as officials of the state.
Thank you, Chairperson. I think, I take it we are dealing with the Friede report, where there are some information in that report relating to some of the information which were never provided then. I must indicate that
You are right, and also accusations against you that you suppressed information, and we want you to speak to those matters so that we don't have unnecessary and undue clouds hanging over your head.
Okay. During the investigation of the Friede report, we call it the Friede report, the complaint was lodged in 2013 with the Office of the Public Protector. We all know by a DA member in the Free State. And again, that member, if you can allow me just to give background, Chairperson. In 2013, according to the report, which is public information, the said member complained about the following issues. That the portfolio committee of agriculture in the Free State around 2013 September heard from the head of the department, Mr. Tabete, that an agreement between the province and the private partners, Estina, was subject to a confidentiality clause. So that's one of the things which raised a red flag to this member. That in terms of this agreement, Estina is partnering with Paras, an Indian company, which will be holding 49% of the shares, talking about the amounts which Estina will be paying, 228 million, and how much will the government be contributing, and that the project planned to milk how many cows. In fact, I'm just telling you what the complaint exactly which we received. And then the next one was we need to investigate the issues of attempt to ensure transparency in the project. So that was one element. The complainant further wrote another letter. Possibly there was nothing which is moving in the office, or the office was busy investigating the matter. But he wrote an additional letter where in 2014 again, where he raised other issues, that it has come to light that Estina will only contribute if necessary, and that they were also benefiting from the supply of goods, therefore, and services from contributions from the provincial government. So there was a concern that the monies which the government will be contributing, 342 million, the Estina was inflating prices. And then they indicated what has been inflated in that complaint letter, and that the Free State government had paid 2.8 million for more for how many cows at that particular period and how much do they cost. I'm just taking you through what the complaint had and what was investigating. That the Department of Agriculture National has already supplied Free State with 40 million worth of equipment, which included tractors and other related issues. That the electronic machine, which is the milking machine, was costing 55,000 per point, which was going to be 30 million. And it also went further to say the goods and services which were provided, the prices were highly inflated. And went on, and that's where they also indicated that there are cows which died in the process, or allegations. By then, the Public Protector is investigating these allegations. Then 2016 again, there's a letter which came forth in May, that the appointment of Estina as a partner in the project did not follow the necessary procurement processes, and that Estina misrepresented themselves, that they are a partner to this Indian company, that the contract was approved by the legal department in the office of the Premier, as confirmed by the CFO, and that Estina was both a partner and an implementing agent, meaning there's a conflict there. And then the issue of the share price, that they would have received 49% share, whereas they would have contributed only 40%. So those were the details of the complaints which the office received. So internally, the office investigated the matter, and according to the officials from the Free State office, they then, because when we receive a complaint, we then determine what are the issues to investigate going forward. At first, when they were investigating, there were several issues which were including even the environmental impact issues and issues relating to in fact, they indicated the issue of the cows which died. They identified that as an issue, but then they never investigated that particular matter, because by then the Department of Water Affairs and Environmental Affairs dealt with that particular aspect. By 2014 already, the investigation had moved very progressively. Internally, there is also an internal think tank process where the public protector sits with the provincial reps and the senior investigators, and Free State is also represented. This matter was discussed in 2014 already, and the investigation was complete, and there was a draft a provisional report. So where the public protector gave direction to the office to finalize the report. So when the 2016 matter was referred to the public protector, already some of the items were investigated in the Estina matter, because it relates to the procurement processes which were followed in procuring the services of Estina. And then when I joined the public protector, this report was one of the reports which was already completed, and it was not one of the matters which was forming part of the think tank list, because when we have issues which are pending, I had to make sure that all those issues which were on the agenda of the think tank we finalize. But this matter came to the fore again as a pressing matter when I visited Free State during the public protector roadshows, where the member of DA complained that they've been waiting for this report for a long time. When am I finalizing this particular report? And I went back to the office to check what is the status of this report. I discovered that is within head office with one of the quality assurance team. And then I said to them, we need to check what is still missing in this particular project. But again, if there's so much money which is alleged to have been spent, I would want to go and see what's happening in the project. I had to go with the team, the Free State investigators, but by then the project was no longer managed by Estina. It was now managed by FDC, the Free State Development Corporation. So the report was already ready, and the only thing which was outstanding was to convert that into the Section 79 notices. Section 79 notices is when there are implicated parties. I must indicate that throughout the investigation, the complaint which was lodged was purely on what are the administrative issues and financial mismanagement. Hence, the focus of the investigation in totality focused on that. And there was no way in the report where it was also implicating certain politicians or stuff like that. And I must indicate that the cooperation, because when the report was compiled, there were stages where the investigators were saying we don't get cooperation from the Free State Department of Agriculture. And also when you write to the MEC, because in this one there is a response they have received from MEC Qabata, I think. And there's nowhere where they've written MEC Zwane, the main issue which people are complaining about. And there were stages where they were not receiving documentation from the HOD, Mr. Tabete, especially of the invoices, because that's the biggest challenge which they were facing. The only invoices they received were relating to the cows which were procured, and I think it was also relating to the milking machine. And what they could do as Free State was to approach Holstein just to compare the prices, but they never went into details to check all the products, or especially when they are investigating this issue of inflated prices. They never then had to check with Holstein and check with other related companies. Hence, I indicated that that process was never done, or that investigation has not been done. So when the Section 79 was issued to the Premier, the MEC of Agriculture, and the HOD, then the MEC indicated, in fact, the issue which was only implicating the MEC was for the MEC to take action against the HOD, and the response was also bringing us to the our attention that the only person who can take disciplinary action in this particular aspect is the Premier, because of the appointment and the contract of employment signed between the Premier and the HOD. And the Premier responded in details in this particular matter, and we've indicated in the report, and the HOD as well indicated that some elements will be in fact, whatever possibly he prepared the response for the Premier, because he said whatever the Premier has signed, it's what he's standing by. And then they provided further invoices, which the office had. On receipt of those other invoices, then I had to say to the head office team, especially the executive manager responsible for the provinces, can you have a team compare what we've received from the Premier now and what is in the file from Free State? So the head office team had to compare the two and check whether the figures were properly captured. And the report was almost ready for issuance. Whilst in that particular process, then I received a request from the leader of the opposition, Mr. Maimane, requesting a meeting to meet regarding the free matter. In fact, he wrote several letters where we were indicating we're still investigating. I must indicate the Free State or the office never investigated also or met or interviewed the beneficiaries in this particular matter, though in the complaint it was also mentioned that there are beneficiaries in this project and they need transparency for the beneficiaries. Then on our meeting with Mr. Maimane, he brought the complainants, all of them, 80 beneficiaries, to the Public Protector. Then on discussion with him, I then requested his assistance because I indicated that the beneficiaries were never interviewed. But then it will help that we get the statements of the beneficiaries because they were indicating we don't know what's happening and how we are treated. We see now things are moving, but then we also have lost our cows because some of them were indicating we were told to sell our cows and then we will be part of this particular project. What we only had in our files, which I'm happy that as well the matter is before court, because DA and CASAC have launched a judicial review, is all the records which we have. The investigation file only has the details of the beneficiaries. Then we agreed with Mr. Mkhwebane, and I also addressed those beneficiaries. Can you please make sure that you write your statements and all your problems and submit to the DA? Mr. Mkhwebane agreed on that December 5 meeting to collate all the information. And also from my side, I said our Free State office should contact the DA member, whatever assistance he can provide to collect the information. Then we agreed that they will give us that information before we can issue the report. Then there was a follow-up in the Free State, and there was a stage when I think it was published in the newspaper where the member of the DA in the Free State was saying there's nothing more he should be giving to the Public Protector when he was followed up, that the Public Protector should be issuing this report because this report anyway has been ready since 2015, and of which that's the case because in 2015 already the think tank agreed that this report should be issued. So then on that publication, there were also allegations now that there are some of the beneficiaries or whistleblowers who are being killed for availing information. And for me, that was also an agent matter to say, we need to be issuing this report so that the criminal investigation, especially if people now are being threatened with their lives in this particular project, then the report needs to be issued as a matter of agency. And whereas there were stages of the Hawks continuously investigating, and there was a preservation order which has been issued against is it Estina or the Guptas who were running this particular project. Hence, the report was issued the way it was issued. But I must indicate that the report is taken on judicial review, and there would be a stage where we will, in fact, I'm more than willing to avail all the records in terms of Rule 53, and all the details of the records are there. Now, on the alleged suppression of evidence, which again, I wouldn't know what evidence is there to which is alleged in the Sunday Times, where again they've mentioned that there are two officials who said there's and those from information from faceless and nameless sources that claimed they've enjoyed close proximity to the investigation. That indicated that there is evidence which is implicating politicians which has been hidden. And I would like to encourage that we study the report and get all the information. What was the complaint, what we've investigated. Again, that will be the report or the records which will avail to the court on what has been investigated in this particular instance. So on the issue of the matter before court, I think honorable members and chairperson, you'd appreciate again on the nitty-gritties of dealing with this matter, because on the issue of the matter now is before court and it will be ventilated in details. Again, dealing with the issue of the sub-judice rule. But all the reports which the Public Protector issues, nobody is stopped to take the matter on review, especially because if people are not happy with the outcomes of the report, and then the matter will be dealt with when it's ventilated in court. But the concerning issue about this matter, again, Chairperson, is that the two have requested again that the court should be issuing personal costs in this particular instance, which has a serious implications for the institution, which is supposed
as early as that, while tenders were going out.
Chief Justice, I make 3 submissions. My clients were concentrating on the tender. The second submission I make is that there was the freezing period. And the third submission I make is they genuinely believe that they could get their act together. But I don't quarrel with the argument that as soon as you seek an indulgence from the court, you go to the court the moment you seek it. I don't quarrel with that proposition. I simply point out that in none of the opposing papers is another solution put forward insofar as that real problem exists. Everybody says we agree you need this service for another 6 months. But nobody says, had you come earlier, you could have avoided it. You can't because you got procurement processes.
No, but it's not known what we would have said had we been approached while there was still time as the court. It's one thing to focus on what your colleagues are saying. It's a
on the 8th of December by the Ministerial Committee. Justice Radebe, in fact, signed the agreement by them to say this particular portion will excise from the agreement. And from there, it became SASSA's problem. So it comes back from the Ministerial Committee, comes back to SASSA, and SASSA must now deal with it as the agent.
You see, Mr. Kasim, if one reads the papers here, and in particular I'm referring to the founding affidavit deposed to by Ms. Bengu on behalf of SASSA, one sees what appears to be a pattern where if you look at what steps are taken either by SASSA or the department to deal with issues that need to be dealt with, they seem to be taking their own time. They seem not to deal with matters with the urgency that the matters deserve. I mean, even if you look at its founding affidavit, you look at what steps have been taken and when.
will be in a position where they go to their scheduled day, because payment is made in the first 12 days of a month. So take a place like Kokstad. It's made in a certain area on Monday, Tuesday, Wednesday. People will go there and there won't be monies available.
So you come to us basically giving this court no choice and saying that if the court doesn't make this order, the social grant beneficiaries will suffer. Is that what you're doing?
There will be chaos. They will suffer. Unless, of course, if they get their act together and they open a bank account, then that solves the problem.
But this is a result of the policy decision on your own version not to take other steps.
Yes, yes. I mean,
is on page 7, on paragraph C again, about the conflict in terms of the Premier of the Free State, because the CFO during the interview confirmed that the Office of the Premier legal team, that the one who signed the contract. So it goes to the second last paragraph about the results of the investigation by the National Treasury, which recommend to the same Premier that the HOD and the CFO must be charged to go under disciplinary processes, which the Premier ignored that. To show that Public Protector, this was a clear syndicate by the Premier and his people there. Because if you can check even the Portfolio Committee in the legislature there, the chairperson was also playing a defensive mechanism not to be asked anything about this project. So the problem now is on your remedial actions. You never mentioned who must deal with the Premier in these circumstances, because you again give the Premier to submit a report within 30 days. What about the matter which conflicts himself as a Premier? Because here he's been seen that he's playing a very important role. So there is nothing where the Premier is held accountable here in your remedial action. So in page 8, there are about 10 issues. You said they were never investigated or entertained because of lack of finance and capacity. So we want to know, as the committee, that at the present moment, do you have any capacity? Do you still have some financial shortage in order to investigate some important matters, because this matter is a public for public interest?
I'm just lost. I don't know what report Mr. Mkhwebane is referring to.
Mr. Mlauzi, I think you must be clear on what we are talking about. And I guess we are not asking you to talk about proceedings in other meetings. We are dealing with the matters before us now. Could you please deal with matters before us and not take us into other forums that said before?
No, thanks, Chairperson. I was talking, as I said, that...
and the report that we are talking about, members are entitled to know which report you are talking about.
Yes, Chairperson. As I said, I'm talking about page 8, Roman figure number 8. Page 8, Roman figure number 8 is there on this document which was supplied to us. If you can read there.
Mlauzi,
Yes.
I think any document that we are referring to has a name, and to assist everybody to know which is report we are dealing with, give us the name of that document. Don't just wave it into the air, because that won't help us.
No, thanks, Chairperson. I thought maybe members were entertaining these documents, but nevertheless, it's the report of the Public Protector in terms of Section 182, 1B of the Constitution of the Republic of South Africa, and Section 81 of the PP Act report. Page 8, Roman figure 8. That's the report I'm talking about, that the Public Protector is telling us here that there are some issues they didn't entertain because of lack of finance and capacity. My question now is, Madam PP, now do you have a capacity to deal with important issues like this, the capacity in terms of human resources and financial resources? That's my question. And Mr. Mwila, I understand you are there now. Okay? So, the last, I have another question about the public protector said there were officials who were not cooperating with the national team which went to Free State. I wanted to know what measures maybe the public protector can say for those officials who do not cooperate with the people sent to go and investigate public's money. And the issue of conflict of interest of the premier himself, through the media, confirmed that his son has a business relationship with Guptas. So, and here we had the company which was dealing there, the Guptas, we heard about the payment of Gupta weddings and everything. So it's a matter of concern for us, public protector, that in your remedial actions, the premier must be included, that what step must be taken against him. Thank you.
Honorable Mkhwebane.
Thank you, Chair. Greetings to you, honorable members, and the leadership from the Public Protector's Office and the Public Protector. As you know, Chairperson, if you are a last person to ask questions, you always run short of the questions because colleagues would have taken everything. But I've just have just few to ask. Public Protector, you said the report was completed in 2015 and was ready to be released. I just want to know whether when you took over office, did you discuss this report with your predecessor, Advocate Madonsela, during the process of handover? I'm of the view that there was that process. Did you touch on this report? Maybe did she brief you as to why some of the things were not covered, especially the issues of the colleagues have been referring to, of interviewing beneficiaries? Because, Chairperson, that one, it's something that I share with my colleagues. Whatever we do as the government, we are doing it for our people there to benefit. Now, if something that concerns them like this, but they are not involved, or their story is not being listened to, it's not okay. It's not a good thing that we should do as the government. I also urge the Public Protector that going forward, ordinary citizens of this country must be the priority. I remember, Chair, she promised us that during the interview that she was really going there to work for ordinary citizens. Now we are discovering things like this where they are excluded in such important issues. I urge the Public Protector that going forward, please prioritize our people, especially on issues of thorny issues like these ones. Number two, in your knowledge, have the Premier of Free State instituted the DC against implicated officials as per the remedial actions that you provided? And also, it's true that what my colleagues are saying, that the Premier is alleged to be involved, and it was all over in the media. I just want to know whether have you consider also writing to the President as the boss of the Premier for an advice as to what should happen to the Premier, because if he's gonna discipline the officials that are reporting under him, definitely his boss as well must do something if there is conclusive evidence that he is implicated. But lastly, Chairperson, the issue of the Gupta leaks, it appears, Public Protector, that it needs a separate new investigation. Now, I will also ask the same question that Honorable Bongo asked, that in light of these allegations, is the office prepared to reopen the investigation on the matter? Because it has been all over the public domain. But also still there on the issues of Gupta leaks. I just want to know that in your office, do you have any formal complaint, apart from the media, lodged against them in relation to this project? And if yes, how far is that in that matter? If not, then will you consider reopening the investigation on this matter? Thank you, Chairperson.
Honorable Buthelezi, you didn't raise your hand. Thank you very much. Mkhwebane?
Thank you, Chairperson. Thank you, honorable members, for your questions. Chairperson, I would like to, again, before responding to the questions, remind the House and the Chairperson about the sub judice rule. But I would want so much to cooperate and work with the committee. And I wouldn't want this process to interfere with the functioning of the courts in violation of Section 165(3) of the Constitution, because this matter will be adjudicated in court. And I've indicated to the House that we will avail all the records in terms of Rule 53. And again, that the aggrieved parties have taken the matter to court because of the issues which have an impact on this particular matter. And again, I have experienced a situation where some of the information which you mentioned on matters which are before court, even possibly issues which are in the media, sometimes they find themselves in the court proceedings, where sometimes you mentioned an issue in a certain context, and that matter also is brought there, and you don't have an opportunity to clarify that particular aspect. So I just wanted to just have an opening that some of the issues I wouldn't be dwelling much on because this process is before court. And responding to Honorable Breitenbach, I think you are quite aware, Advocate, that the Public Protector doesn't have jurisdiction over any criminal matter. Issues relating to, because you've referred to money laundering, theft, and which were not investigated, and those issues are criminal matters which are being investigated by the Hawks. Indeed, that was never investigated. And again, to confirm that the matter was finalized, the investigation, according to the information from the investigators in my office. The investigation was completed in 2014, and already by 2015 at the think tank, it's an internal structure discussing all the reports, where there would be a publishing of the said reports. and the decision was taken that the report is ready. And what happened is that the only time the Free State office had to be engaged about this report, it was in 2017 when I visited, in fact, 2016 when I visited Free State, and the matter was raised that this report should be issued. So that addresses the issues relating to the investigation. On the issue of why I didn't increase the scope, the investigation, all the investigation, when I joined the Public Protector Office, a lot of them are like this one, which were at an advanced stage, and the report has been drafted already. The issues, because when we receive a complaint, we assess the complaint, we determine the issues on what happened, what should have happened, and the difference from what happened and what should have happened, and the prescripts applicable to this. This matter purely focused on the issues of maladministration and the issue of the way the resources or the agreement was entered into, the way the project was managed, and the way the Free State Department managed this project. It was more of the investigation focused a lot on the violations of the PFMA. And again, I agree with you, Advocate Breitenbach, that a lot of the information which, in fact, the report of the National Treasury was, yes, incorporated in this, because indeed the HOD and the relevant officials violated the prescripts as far as this matter is concerned. On why not increasing the scope, a lot of the reports the Public Protector we draft, there is an element of the prejudice suffered by the complainants. And in this particular instance, the investigation never concentrated much on the beneficiaries. It concentrated more on the gist of the complaint, how the agreement was entered into, the issue of inflation of the prices, and the issue relating to the monies which were spent and there was no product which was produced. And I indeed agree that the issue of the Gupta leaks, and which I've mentioned, again, the investigation, the way we conduct it, we don't just write or take information from the media and include that information in the report. Again, we're going to be facing a challenge where we are accused, because any other person will also be having a challenge, that you cannot use any information just because it's mentioned in the media and use that as the evidence, because when you have to use that information, you'll have to go and investigate yourself as the Public Protector and satisfy yourself that this is the information which I have on record, and is the information which, even if taken to court, I'll be able to defend, unlike taking an information which you hear from the media. Indeed, the Gupta leaks were received by the office from outer, and I shared the information with the Free State office to say this is the information, but we cannot rely on this information. We will have to do our own investigation. But then when we discussed again, it was an issue or that already the report was focusing on a totally different or different issues. And I indicated earlier, Honorable Mkhwebane, that the Gupta leaks, in fact, there's no complaint which is received by the Public Protector specifically relating to the Friede matter and the Sun City wedding. The issues which were lodged by CASAC to the office, especially relating to the Gupta leaks, they are part of the investigation, mostly relating to, is there in the statement where I was clarifying the issue of the terms of reference, where some of the issues which are indicated in the Gupta leaks are some of the issues which I was saying if they can also be included in the state of capture terms of reference. But then this one is not part of that, and there was no direct complaint about the Gupta leaks in 2017. Hence, I've indicated this report was investigated 2013-14. Already the investigation was complete, and then it was ready for issuance in 2015. And the Nkandla judgment, Honorable Swart, I agree with you. Indeed, that's our focus as an institution, that everything we do, we need to make sure that whoever is impacted by the decision of our investigation or of the maladministration needs to be given redress. The beneficiaries, the way the office investigated, it was only getting their details, because in the original complaint was referring to the issue of what the beneficiaries should be, there should be transparency as far as how this project should be managed. Indeed, I think dealing with Honorable Horn's question, also why some of the complainants were not interviewed. It was only like since 2013-14, only getting their details, their IDs to see is there beneficiaries or is just allegations. So that information was acquired from the Department of Agriculture. And in fact, by that time, there were only 78 beneficiaries whose details were received, all of them. But then those beneficiaries were never interviewed. Hence, I'm saying when meeting with the Honorable Maimane, that was the time when I wanted us to get the details of the beneficiaries, which were not forthcoming, but at the end of the day, the key focus of the investigation was that. Again, if expanding a scope just at the report writing stage, again, that's one of the issues which one was accused of doing in the Murphy judgment on CX, that how can we include issues of relating to the prejudice which is suffered by South Africans in that particular aspect, but we're still going to deal with that matter. Therefore, you cannot just include information which you didn't investigate in the drafting of the report. And I agree that indeed the beneficiaries were impacted in this matter, but the investigation never focused on the beneficiaries. The investigators focused on the violation of prescripts by especially the accounting officer and stuff like that. The conflict of interest of the Premier.
It is not permissible to raise banners in the Committee of Parliament. If that continues, the holders of the banners will disqualify themselves from being present in the meeting. This is a committee of the Parliament of the Republic of South Africa, is an organ of Parliament elected by the people of South Africa. We all have to respect the people of South Africa who elected this parliament. So can we all lower the posters or leave the hall.
Chair, I suggest we should possibly adjourn the meeting for a few minutes.
The meeting will stand adjourned. We will not leave the room, but we can't continue the meeting when there is defiance of the committee and the Parliament of the Republic. I hate to say that unless those who are raising the banners lower them, they will have to be removed by people that are entitled to maintain order in the proceedings of Parliament. I hate to have to say that, and I would request that you voluntarily lower the banners or leave the house to avoid unnecessary will we ask those that are responsible for the maintenance of order in the proceedings of the committee to ensure that nothing happens in this meeting which should not happen? Can you move in and ensure that I must apologize to the honorable members, and we didn't foresee that anything of this kind would happen, and therefore we didn't take the necessary measures to prevent it. But I think we are happy that those that were not supposed to do what they did agreed to leave the room without any inconvenience to yourselves. May we proceed?
Thank you, Chairperson. On the issue of conflict of interest by the Premier, that matter was not investigated, and the matter can gladly be investigated if the complaint is lodged in terms of EMIA. Because, as I've indicated, the focus of the investigation was purely on administration or maladministration and the abuse of state resources by the administration. The referral to Hawks, Honorable Swart, the remedial action didn't include this because already the matter was at an advanced stage, as I've indicated, that the Hawks have already acquired a preservation order against the impacted officials. Indeed, the Public Protector Act does allow one to do that, hence there would be referral to either the DPCI or to some of them. We also refer the SIU to conduct an investigation. And indeed, in the investigation, there was never a point where one is not taking into consideration the provisions and the prescripts and what laws have been violated, especially the Constitution. And that was purely based on what the complaint was, and the investigation focused on the issues which were there. And when the report, because the report, when I joined the office, the report already was at an advanced stage, but then it was not issued immediately when I joined. It was an issue of making sure that I go and see. As I said, I conducted an inspection in loco, but again, I requested further details, especially after meeting with the DA about the complainants, where I requested their information. But that was already, issues have already been determined, and the issue of the prejudice to the complainant, which was also never investigated. I must indicate that that matter was never investigated, hence it was never included as one of the issues, because the complainant focused more on Estina, the agreement which has been signed, whether the procurement processes were followed, whether the prices which were charged by that company were inflated. And I must indicate that the agreement was drafted by the legal department in the Premier's office. Hence, one of the findings is that the disciplinary action should be taken against whoever or the officials, because those officials in the legal department, the way the agreement was drafted as well, it was in such a way that it was, you can consider it as not being properly drafted, and it allowed a lot of leeway for the company compared to protecting the government. And that is part of what the remedial action or the finding was, and the remedial action to that effect was taking disciplinary action. And the decision which was taken by EXCO, Honorable Horn, the information which we have in the report, that decision was taken by the executive, and the provincial treasury was represented in the meeting. But then the process was delegated, or they gave everything to Mr. Tabete to run with the process. If you could see, the agreement has been signed by Mr. Tabete, especially the agreement between Estina and the government. And in the investigation and the records which we are having, all the information was pointing to the relevant officials, hence the investigation concentrated more on them. And on the issue of Mr. Skosana, the public interest. The report, I'm obliged in terms of the Public Protector Act to publish the report. The publication, I can use any form of publication. It's not obligatory for me to call a media briefing. But in this particular instance, the report was published in the Public Protector website. The media statement was issued to this particular instance. So the Section 8, subsection 3 says the report should be published unless there are issues of confidentiality which the Public Protector might decide not to publish the report. So the issue of publishing in the website was part of publishing the report. Honorable Maila, yes, the report was ready for issuance because the records in the Public Protector Office reflects that the report. The investigators were informed that the think tank decided the report has been finalized. It should be issued in 2015 already, but it was never issued. And the only time the matter was revived, it was when I joined the office, and I had to ask, why are we not issuing this report? Because it's a matter of which is been raised by the executive or the members of parliament in Free State. And I agree with you that the focus, especially of the Public Protector, the Vision 2023, is the focus on the grassroots and empowering the beneficiaries. That particular aspect can be investigated as a separate matter. I think Honorable Bongo asked whether this matter can be opened. Functus officio, so that report is issued, is finalized, unless set aside by a court of law. Therefore, if there's there can be a complaint which is lodged, and one can investigate, or then it can be an own initiative where we investigate that part of the beneficiaries. But I must indicate that the judicial review by CASAC has one of the prayers is the report be referred back to the Public Protector for investigation. Honorable Mutapo, indeed, that is a constitutional obligation for accessibility of the public to the Office of the Public Protector, and again repeating the fact that the grassroots are the key, and the issue of the beneficiaries, because most of our reports have an issue dealing with the prejudice suffered by the complainants. Normally that aspect is dealt with, but in this one it was never dealt with because there was no investigation, especially on the prejudice by the beneficiaries. The focus was more on maladministration and all those. But again, as I'm saying, that this matter, when it's brought back to the Public Protector, or then the investigation can be on own initiative to investigate this particular matter. Honorable Mulawudzi, the 30 million on page 4 of the report, whether we have the back breakdown, I don't know whether we've checked, colleagues, whether did we check what was that, because we do in the body of the report, you'll see that there is a lot of invoices which we received from some of the invoices which we received from the Free State Department, the ones which I was saying, some of them were received when I joined the office. The lot of resistance was when this matter was investigated, and when the investigation was conducted, there was never a stage where possibly a subpoena is issued, because in terms of the Public Protector Act, you can issue a subpoena, or you can subpoena the documents. and I indicated that when I took over, the report was drafted, and when we issued the Section 79, it's when some of the invoices, they were submitted by the Office of the Premier with the response to the Section 79. So if you go through the report, I think page what? Page 5. I think page 5 of the Friede report. But I think in the body of the report, I just wanted a page in the body of the report where we are analyzing all the statements. But page 5, what does it say? I think page 5, it does indicate that the top range rotary machine, the cost was 55,000 per point, and for 82 points it was should not have cost more than 4.5 according to Holstein, but then this was charged at 30 million. So that 30 million was the price of this rotary milking machine, according to the information which we received. And then on page 7, you are referring to the issues which were never investigated. Or the contract which was signed by the legal department. I think that I've explained to Honorable Horn that the very same legal department, because we were saying the contract, the way it's drafted, appeared to be not complying to some of the prescripts of the law of contract, and that's one aspect where those officials should be disciplined. The Premier never charged the officials, ignored that, because in his response, he indicated that after the Accountant General has issued the report, where there was a recommendation to take disciplinary action against the CFO and the CEO, then he indicated that he's waiting for the Public Protector to finalize the report before he can act. So he never acted immediately. So that's one aspect which has been indicated in the report, that he never. So now, because the report is finalized and we indicated that he must take action within 30 days, I think that will be done. My concern also is, as I've raised it, that there was no complaint about the executive, the violation of the Executive Members Ethics Act by the Premier. And there's nothing which is stopping members of the executives to do that as far as this matter is concerned. But this matter, when it was lodged, it focused more on the issue of the way the contract and the resources were utilized. And if it comes to the investigation in terms of EMIA, then that's where the issues of conflict of interest and the issues of the behavior of the Premier in terms of the law will be dealt with in details. And there was a question about whether we have the capacity, because some of the issues we never investigated, especially the one of the death of the cows. It was never investigated because already the Department of Water Affairs and Environment dealt with. And then the other issues, we relied on the report of the Accountant General, because already the value for money aspects were dealt with in that particular report, and there are observations and findings as far as that is concerned. And on the issue of the capacity now, I think there's no capacity in the office, and Yes, our budget has been cut further in this financial year, so we don't have the capacity. On the issue of the officials, they've been dealt with, or they'll have to be dealt with. The issue of the Gupta wedding and the Gupta leaks, as I indicated earlier, there was no direct complaint, but then that is not stopping the office from or any complaint being lodged, and we can investigate that particular aspect. Again, not doing on initiative is considering the capacity which the office is having, because the Public Protector Act does allow the Public Protector to conduct own initiative investigation. Honorable Mkhwebane,
Chairperson?
Mkhwebane.
Yes, Mkhwebane. My father can really
My apologies,
contest that,
Honorable.
yeah.
Yes, I didn't see you, so I thought they were saying Mkhwebane. Honorable Mkhwebane. Yes, the report was ready in the think tank. It was discussed and finalized by then, and you saying during the handover, the handover report which I received, the matter was not part of those included, but it was part of the, as I've indicated, it came to the fore when I went to the Free State, and there was that complaint that this report should have been issued long time ago. And again, when I requested the beneficiary information, the complainant was also saying, but this report is complete. It was ready for issuance. So it was part of that process of making sure that all the matters which are ready for finalization are dealt with. And I agree with the issue of the beneficiaries. The reopening, it is not possible because of the functus officio rule, and one of the prayers is to take the matter back to the Public Protector. On the issue of the Gupta leaks, the complaints which we've received about the Gupta leaks, which was lodged by CASAC, this matter of Friede was not included in them, and I've mentioned in the statement that some of the issues which were additional to the state of capture, which were not part of the report, the allegations which were relating more on ESCOM and issues relating to high-level information by Minister Mutambi and all those. But the issue of Friede was never part of that complaint. Again, it doesn't stop the complaint be lodged to specifically investigate that particular matter. Thank you, Chairperson.
Members, have you been answered? Can we close this Honorable Skosana?
Yeah, no, thanks, Honorable Chair. Yeah, I think on my part I'm answered, except on one question where I asked about the Public Protector indicated earlier that she struggled to get some of the information from the Department of Agriculture in Free State due to the lack of cooperation. So I then asked as to, is she satisfied where she is seated about the information that she was able to get, as she indicated earlier that she struggled to get some of the information. Is she satisfied that she received the necessary information when she concluded the report? Thanks.
Thanks, Honorable Chair. Look, I don't know if the
Public Protector is aware that as we speak now, no action has been taken against individuals pointed in the Free the dairy scandal. As we speak now, Mr. Tabeta is still reporting for duty as usual, as business as usual. Has she bothered to know from the Premier of the Free State, whoever that Premier is, I don't care, what corrective measures has been taken in relation to the report of the Public Protector, in relation to Frede, especially about officials who are implicated? And secondly, I must express our disappointment as members of Parliament, especially speaking on behalf of the economic freedom fighters, that the Public Protector general attitude is pushy-footing on the findings her office makes and adopts an attitude of I don't care. We wonder when will that attitude come to an end? Can I be allowed to speak? Can I be protected, Honorable Chair?
Can we allow the freedom of speech, because it would be difficult to prescribe how people, point of order, let's hear the point of order.
I think it is not correct to attack the person of the Public Protector, and I think it is not allowed to attack the Public Protector, particularly in a meeting like this. All I request that the Speaker could probably talk about something else, about the work, but not the person of the Public Protector. Thank you very much.
We have had a report. Can we put questions on the report other than pass judgment? Because the idea is that we must get an account of what happened, not to pass judgment. That belongs to something another time.
Well, I hope you're not sustaining the point of order, because that point of order is in itself entirely out of order.
You as to the approach.
Okay.
Thank you.
Okay, thanks so much for not sustaining that out of order, because in itself out of order. Let me proceed.
Excuse me.
This is my last comment.
I just wanted to find out, are you saying that it is correct for the honorable member to attack the person of the Public Protector? Is that what you are saying?
My answer is that this is the time to put questions, and Honorable Matthias must ask questions, not to attack or pass judgment.
I want to know from the Public Protector that have she taken trouble on the basis of comparative analysis of what would have been the money or the value of the investigation which was carried out by the Free State Department of Agriculture in Russia on the specification, the required specifications needed to initiate a project of that magnitude, which cost taxpayers more than 230 million. Whether has such a comparative study or analysis done, if such a study or a service was acquired internally in the country, because I can tell you,